Good afternoon, good evening, and I guess good morning for those who are really west of here. Welcome to the third edition of World Arbitration Update. My name is Ian Laird. I'm co-founder and co-chair of the conference, along with my colleague, Dr. Jose Antonio Rivas. We founded World Arbitration Update 3 years ago, partially in response to during the COVID epidemic, in response to what we saw as a need for people to get together, and a lot of conferences had been canceled or delayed. And we thought that would be a great opportunity to have a virtual conference. And we're largely keeping that up, although we had a great 2 days in Mexico City the end of last week at the National Autonomous University in Mexico City. We had over 950 participants virtually and in person at the university, and 8 panels. And it was very successful discussion of investment treaties and the NAFTA and the USMCA and all sorts of issues related to international investment arbitration, commercial arbitration, and international law, which is part of what our objective at WOW is to address issues in respect of those topics from around the world, because one of the things that we noticed in particular in setting up WOW is that international arbitration has really spread from each corner of the globe. It's not just something practiced in the major centers and under the major institutions, but in every region of the world. So we set up the conference to basically reflect that diversity and the wide nature of international arbitration practice. We started last week with a couple of days on topics with regard to the Americas. Today, we're focusing on topics related to Middle East and Africa. And this is our last panel for today, but we will move to Oceania tonight and tomorrow morning Singapore time. And just to give a brief promotion for that panel, the role of domestic legislation on evidence in international arbitration proceedings will be a panel tonight, tomorrow morning Singapore time. But I wanted to get to today's panel and welcome our panelists and moderator to a panel titled Consequences of Energy Transition Policies for Investment Arbitration Disputes. And clearly this is a growing and continuingly important topic in international arbitration in general, but in particular in the Investment Arbitration Disputes Forum. And I wanted to introduce our moderator for this panel, and she'll introduce the panel and get the discussion going. We're very grateful to have Christina Bahari from Foley Hoag. Christina has worked in the public and private sector, representing and advising states and state-owned entities on international disputes and public international law matters. She has represented states in various forums, including the ICJ, ICSID, PCA, ICC, and under the UNCITRAL arbitration rules. Christina previously served as counsel in the Trade Law Bureau at the Canadian Department of Foreign Affairs and International Trade, and representing the Government of Canada in investor-state disputes under NAFTA Chapter 11. As well, she has experience in GATS and other trade agreements. We're really privileged to have Christina here today, and I'll pass over the microphone to Christina, and we'll get the discussion going.
Thanks, Ian, for that warm welcome. And welcome to all of you today on today's session on the consequences of energy transition for investment arbitration. So our panel will tackle the seeming tension between the policy goals of states to act in accordance with their international obligations to reduce global warming on the one hand, and their obligations under investment arbitration treaties on the other. So to address this topic, I'm joined by a group of leading figures in the field of international investment arbitration, who I will now proceed to introduce. Starting first with Maria Lucia Casas. She's a Colombian lawyer specializing in the regulation of renewable energy and energy efficiency. She is a senior associate of Strategy and is based in Bogota. She's also an adjunct professor in international arbitration and an assistant professor in public international law at the Universidad del Rosario. Louise Barber is a senior associate at Herbert Smith's International Arbitration Group in London. She works on both commercial and investment treaty arbitration and specializes in energy disputes, particularly those involving energy transition and climate change.
Christina?
Yes.
For some reason, I'm not sure if the sound is well. I don't know if everyone could hear you. Okay, I'm sorry. Go ahead, sorry.
Can you hear me? All right. So Louise is also experienced in advising on a range of public international law issues, including boundary disputes, law of the sea issues, and treaty interpretation. Garrett Rush is a managing director at Secretariat and is based in Washington, D.C. He's been a damages consultant and expert for both claimants and respondents in international disputes for approximately 25 years. He's worked across all major industries, including the extractive sector, electricity generation, and electricity distribution. Lisa Sachs is the director of the Columbia Center on Sustainable Investment, which is a joint center of Columbia Law School and the Columbia Climate School. She is a recognized expert in the ways that laws, policies, and business practices shape global investment flows and affect sustainable development. And finally, Julie Carey is the managing director at NERA. She is an energy economist with 25 years of experience providing expert evidence in energy and transportation related disputes. Julie frequently conducts economic analyses on energy markets, contract, regulatory policy, as well as damages analyses. Julie is also an adjunct professor at Georgetown University, where she teaches a graduate level course on energy economics and policy. So the format of today's session will consist of first a presentation by Maria Lucia, and it'll be followed by a panel discussion. I would invite all of you to enter any questions or comments you have in the chat function. And without further ado, I'll turn the floor over to Maria Lucia for her presentation.
Thank you, Christina, for the introduction, and thank you, Jose Antonio Nian, for the invitation. I'm very excited to be here today at the third day of World Arbitration Update in the Middle East and Africa Day. And of course, it is an honor to be sharing this panel with Christina, Luis, Julie, Lisa, and Garrett. So to start with the introduction of our session on the consequence of energy transition policies for investment arbitration disputes, the first thing that I would like to raise is that according to the latest ICSID report, almost half of the ICSID cases in 2022 were related to the energy and mining sectors. Also, I would like to highlight the Pinsent Masons and Queen Mary's survey report on the future of international energy arbitration, which was published at the beginning of this year, that suggests that one of the causes of international energy disputes is climate change and environment. As we all know, nowadays states are under pressure to issue regulations to mitigate the effects of climate change and to comply with the new international environmental obligations that all states have assumed, mainly under the Paris Agreement. As a consequence, over the past years, regulatory changes in response to climate change have been introduced at an unprecedented rate, And this regulatory inflation is expected, of course, to keep increasing as a consequence of the new state's obligations regarding climate change. These have caused that governments face two competing objectives at the same time. On one hand, trying to move on energy transition forward and implementing the NDCs that they have made under the Paris Agreement. And on the other hand, the obligation to respect the rights of companies and investors that owns assets in the energy production and transmission sector. It will be very important to see how this tension between these two competing objectives plays out in relation to the pre-existing investments. But what we have seen so far is that this tension has produced, of course, an increase in investor-state arbitration disputes with the objective, of course, to challenge specific climate measures. Some examples of these include cases such as Uniper versus the Netherlands, Rockhopper versus Italy, and Granada Private Power versus Granada, which our panelists will explain in a few minutes. Another issue that I would like to take into account here and to raise to our participants is the fact that investment treaty landscape was conceptualized way before the emergence of the climate crisis. So of course, most of our investment agreements are silent on environmental issues that might be related to the energy transition. Nevertheless, in the last few years, there has been a changing with the introduction of new generations of international investment agreements that may contain carve-outs, states' rights to regulate, and obligations of investors to protect environment and to respect human rights. This development, it is evident that highlights the growing concerns that states may have to balance their environmental policies with the commitments that they have made way before to the foreign investors. Examples of these new generations of agreements are, for instance, the Netherlands Model BIT, the Moroccan IRIJA BIT, and the Singapore-Indonesia BIT. These agreements contain progressive features that recognize an explicit right to regulate an investor's environmental obligations. For instance, an example of this is Article 6.6 of the Netherlands Model BIT, which incentivizes foreign investment that aligns with the imperatives of the Paris Agreement. And of course, this provision reminds the parties, or might remind the parties in the future, that they are not free to opt out of their obligations under the Paris Agreement, but what is more, that they reaffirm their commitments within the scope and application of international investment law. Another trend that I would like to highlight under this discussion is the modernization process and withdrawal of the Energy Charter Treaty that was announced last year, as a consequence that states are alleging that the treaty does not go far enough to address their climate change obligation. So this modernization process may have some material consequence for the state regulation and of course also to investment related to the energy transition. Given this situation, some outstanding issues that must be resolved during this panel, and luckily is not my place to answer to, are whether ISDS protects fossil fuel investments, whether ISDS is subject to fostering investments in renewable energy, and which is the role of our experts in the assessment of the policy and regulatory causes of a potential alleged harm in a particular case. So with this introduction, I would like to yield the floor to the panelists with the very difficult task to answer some of these concerns and questions that are like a very hot topic nowadays.
Thank you, Maria Lucia. I'm gonna start with Louise. Louise, can you give us an overview of the case law concerning investment arbitrations that have arisen from the energy transition policies of states?
Sure. Thanks very much, Christina, and good morning, good evening, everyone, depending on where you're joining us from. And thank you very much for having me. I'm just going to put my slides up on the screen. Okay, is that visible to everybody? Great. Okay, so I'll be presenting a high-level overview of the ISDS claims that have arisen from the energy transition to date. This is not going to cover every single case, but it's hopefully going to set out some broad trends, which will then allow us to discuss these points further throughout the panel discussion. So the first thing to say is to echo what Maria Lucia said, which is that the energy sector has traditionally made up a very sizable portion of total ISDS cases. So it's by far the largest share of cases administered by ICSID. Almost half have come from the energy sector. And this is not surprising if you've worked in this sector, thinking about the nature of the projects involved. So they often require some sort of state involvement, like concessions or licenses being granted. It's a pretty heavily regulated sector. There's a high degree of foreign investment involved a lot of the time. It's a very kind of international sector. And then the projects themselves tend to have huge amounts of money involved, huge amounts of risk involved, and then they are often planned to be to operate over very long time horizons. So all of that really sets out quite fertile conditions for disputes to arise between investors in these projects on the one hand, and then states, because there's a high potential for regulatory conditions to change and for state actions to have a significant impact on these projects. And it's a reflection of the close relationship between the energy sector and the investment treaty system that we have the Energy Charter Treaty, which is that the multilateral investment treaty designed to address investments in the energy sector specifically. And we'll no doubt come back to this in the course of this panel, but there have of course been lots of changes in the membership of the ECT in recent years. But at its height, it's had more than 50 countries as signatories and many more as observers. So it really has been one of the largest multilateral investment agreements in the world. But today, we're not talking just about energy-related cases. We're specifically discussing energy transition-related cases. So by that, I mean the broad drive towards decarbonisation that's being pursued to varying degrees by both states and private actors around the world. And so the focus on the one hand of the reduction of carbon emissions from industry, from existing projects. And then on the other hand, the increase in the use of low carbon and renewable energy sources to replace fossil fuels. And so against this backdrop, the pace of regulatory change has been increasing very substantially in the past decades. And it can reasonably be expected to do so even further going into the future. And then the final kind of general introductory point to say is that we've historically seen a very high number of cases in the investment system arising from measures taken by states for environmental reasons. And we've been seeing this increase in recent years. And so all of this really just sets the stage for many more disputes in this area arising from the energy transition. So turning to the types of cases that we've already seen, I put the energy transition claims into three general buckets. So the first category is claims arising from changes to existing regulation. And so these claims might arise in response to changes in regulation in pursuit of particular decarbonisation objectives. And usually in these claims, those measures are alleged to make the performance of an investment more onerous or potentially impossible. So the most prominent examples of these claims are the series, a very large number of cases that have been brought against Spain, Italy, the Czech Republic, and then more recently Romania, where incentives encouraging investment in solar power and other renewable energy technologies were introduced and then later were allegedly withdrawn or downgraded after a large number of investments had already been made. And so there have been a huge number of these cases brought, I think more than 50 at this point. And so they really do occupy a quite kind of disproportionate number of the total ISDS cases. And so the claimants in those cases argued with mixed success that the states in question had breached the protections that they offered to foreign investors under these treaties. And many of them were brought under the ECT specifically. And that basically the state decision-making in connection with these incentive programs amounted to a breach of the treaties. And in particular, there was a focus on the investors' legitimate expectations around the basis on which they were alleged to have made their investments in the sector on the basis of the particular what they say were commitments that were made by states. There's also been at least one similar case brought against Germany of late, or it's threatened at least, in relation to the offshore wind sector. So all of these claims have arisen from measures which states have introduced in pursuit of energy transition goals, but where investors say that the way that those policies have been implemented or changes that have been made to them have affected their investments. So that's the first bucket. The second bucket is where a new policy or regulation has been introduced as part of an energy transition strategy, and then you've seen claims arise in connection with those new policies. So as was mentioned in the introduction, there have been a number of claims that have arisen from the introduction of phase out policies for specific types of energy. So this is very much focused on coal. So we've got the Uniper and RWE claims against Netherlands, where in essence, the Netherlands had introduced a piece of legislation that required all of the country's coal-fired power plants to be closed down by 2030. And that was as part of the Dutch government's broader decarbonisation commitments. And it was also said to be pursuant to the pledges that the country had made under the Paris Agreement. And so while some companies received compensation from the government in connection with the impact of this bill on their coal-dependent businesses, Uniper and RWE did not. And so the claims were essentially around the compensation mechanism and the way that was being implemented. There's been a similar claim against Canada brought by the Westmoreland Coal Company around the government of Alberta's commitment to end the use of coal-based power generation by 2030. And that was a claim under NAFTA, and then a new claim more recently under the USMCA. And again, that was kind of very, very much focused on the implementation of that compensation mechanism. And then we've also seen a couple of other cases around uranium mining and the use of nuclear power. But again, a kind of around the introduction of policies to phase out those activities. And so a common feature of all of these cases has really been an acceleration of the timetable that's been set down by a state for transitioning to different sources of energy. And so you find that commercial parties which had made investments on the basis of a different timetable, and in some cases allegedly on the encouragement of the states in question, might have found themselves facing a different regulatory framework which doesn't sit very well with the planned lifespan of those investments, and so which then kind of jeopardizes the recovery of those investments. And then the third category, the third bucket, is claims which arise from particular decisions by states in respect of specific projects. So this is often taken the form of the denial or withdrawal of particular approvals or permits or licenses for particular projects. So most notably, there's the Trans-Canada case against the USA, which was around the construction of the Keystone XL pipeline, which of course has been very prominent. And similar, we saw the Rockhopper in Italy case, which is where an offshore oil concession in Italy had been granted. There was a change in law which sought to ban further offshore drilling projects, but provided that it would grandfather in permissions for existing projects. But as a result of some public outcry, the government then removed that exception and sought to shut down this particular concession. And so that was where the claim came from in that instance. And then look, a series of other cases that kind of have a similar fact pattern. But the point is that the connecting thread between all of these claims is commercial actors who are seeking redress for the impact of state level policy changes around decarbonisation. And so given the pace and the scale of the change that we're seeing from states in this sort of regulatory activity, we can fairly expect to see more of these claims arising in the future. And so looking to the future then, and the sort of trends that we might expect to see coming down the line, I guess in terms of broad themes, first of all, there's lots of activity on the enforcement front that we'll expect to see arising from those solar cases in Europe. So lots of these cases are running afoul of intra-EU BIT issues. So even where awards have been made against states, it's been proving quite difficult to enforce those awards in Europe. So we're seeing a lot of attempts made around the world, including in Australia, in the US, and in the UK to try and enforce those awards. And so we'd expect to see a lot of activity on that front in the coming years. The second point I'll say is that a theme has been that there's been a pretty high number of dissenting opinions in these sort of cases, let's say more than average, in these kind of climate and environment related cases. Which is very interesting, especially in the Eco-Oro and Columbia case, where there are in fact 2 dissenting opinions. And, you know, I think this reflects that these are very difficult issues, and some elements of them about the balance between what can reasonably be expected of states when they are dealing with environmental issues is likely to generate more dissents. The third point, which is a very interesting but very complicated one, is around the potential for claims arising from a state's inaction or a state's kind of failure to act. And, you know, so this might arise in the context of a failure to enforce environmental regulation, for example, or a failure to take what is considered to be necessary action on climate change. And an interesting parallel is to look at the Allard and Barbados case, where the claimant had said that Barbados' failure to take certain environmental protection measures was what had caused the destruction of value in the investment. Now, that claim failed, but in the course of doing so, the tribunal did suggest that consideration of a host state's enforcement of environmental issues could be relevant to the full protection and security standard, which is a very interesting way of effectively leaving the door open to these sort of points being considered in future. And then just to mention that there is, of course, the advisory opinion that's been sought from the ICJ on the status of states' obligations under international law in respect of climate change. And depending on the outcome of that, we might see claimants trying to rely on that sort of decision in future to say that states should have been doing more and their investments might have suffered as a result. And the final point I'll say is just that we might see more attempts by states to bring counterclaims against investors related to what they allege are those investors' non-compliance with environmental and climate-related measures, either through domestic law or treaty obligations themselves. Now, mostly the challenge has been with these sort of counterclaims, various jurisdictional issues, or a lack of a substantive basis in a treaty to impose positive obligations on investors. But as was mentioned in the introduction, we're seeing more interest in drafting in more reciprocity of obligation in this new generation of treaties. So I think we'll come back to that later in this panel, but I think there's hopefully plenty of food for thought there in the meantime. So I'll pass back to you, Christina.
Thank you, Louise, for that excellent taxonomy of disputes and identification of key trends. I'm going to turn to Lisa and ask you, Lisa, do you have any additional thoughts or observations to add?
Yeah, thank you so much, Louise. I also thought that was a really excellent, incredibly helpful organization of the cases that we've seen and the trends. I think the only thing I would add maybe to the trends is the real clash between the cases, the types of claims that are being made and states' other international commitments, the commitments that states are making to address this existential climate crisis. This is not a kind of typical dispute between states' prerogatives and private interests or profit interests. This is probably the largest existential challenge that world's governments have had in our generation, which is how to restructure the global economy to try to stay within inhabitable warming limits. And that requires massive restructuring, massive investments, massive policy flexibility, massive negotiations, and so on. And states are making these types of commitments in international binding mechanisms like the Paris Agreement, but also at the G7 level, at the G20 level, at ministerial fora of energy ministers, of ministerial fora among finance ministers, and so on. And so I think the other bullet I would add is the real tension between the obligations and investment treaties that underlie these disputes and those commitments and the imperatives for states in taking action. And I think I would just note and maybe preview for later in the discussion that that's exacerbating, I think, the backlash against this system that, predated the energy transition and predated the climate crisis, because it's always been a concern to many that investors are able to challenge public interest measures in these often closed door fora without the proper integration of these other international commitments and stakeholders. But I think that the tensions in the climate space have really accelerated, I would say, maybe that backlash. And I'll just end with Louise's helpful note that the Energy Charter Treaty is probably a central treaty in all of this. And it's also the focal point for a lot of the backlash right now. There's, as I'm sure everyone on the call knows, there's a vigorous public debate in the EU, especially right now, although global participants are participating in the debate, but a real vigorous debate about whether the Energy Charter Treaty can be consistent with the energy transition and whether the steps that the members have taken to attempt to modernize, so to speak, the treaty are sufficient. And the resounding call from many is no, and we've seen many European states withdraw from the treaty or indicate their intent to withdraw and call on the European Union to withdraw as a whole. So maybe I'll stop there just to say that this is really setting up an even bigger tension, I think, than those that will exist between investors and states.
Thank you, Lisa. We're going to shift gears now and look at some of the quantum issues related to renewable energy. And I'm going to turn to Garrett now. Based on your experience as a damages expert, what are some of the unique characteristics of these cases from a quantum perspective? And what are the quantum issues that are most frequently debated in these types of cases?
Sure. Thanks, Christine. I'm going to share my screen too here. And I'm starting with, when we talk about renewables, what's interesting to us as quantum experts is, of course, sort of what industry are we talking about? What sub-industry are we talking about? And we've looked at the awards since 2018, and there are 49 we're able to review that are publicly available. And here we have a breakdown of what those where those fall in terms of the industry. And you can see it's dominated, when we talk about renewables, it's dominated by solar and investor state disputes. And that's 30 of the 49. And then of those, we all know kind of that's dominated by Spain too. The second bar is interesting because it's the hydro bar, but hydro is by far the biggest renewable source of electricity, but it's not generating nearly as many cases as some of the others, and specifically solar. And we'll see why. I think it's natural that solar is number one, just given the flows of investment between countries and cross borders. But wind would be next to solar, around the same in terms of the power produced in the renewable sector by wind and solar, around the same. So those are the dominant cases we've seen in the renewable sector. And of interest to us, on the right side of the screen, you can see that most of these, and this is always a little bit surprising to me, most of these matters involve operational facilities. So they're producing energy, they've been built, they've attracted investors, and they're producing energy. Only about 20% are pre-operational, so not producing energy yet. And I think that's actually a little bit skewed compared to other industries we see. We see generally more pre-operational projects in investor state disputes than what's reflected here for the renewable sector. And what we do when we have operational projects, and this has been true of the awards, is that we're able to use an income approach, which means the damages are usually calculated looking forward across the lifespan of a project. And so there's projected performance that's discounted back to evaluation date. And so that's been consistent. We see a lot of income approach applications in these damages awards. just going back in this next slide to the point I was making about the investment flows. And you can see on this left side of the screen, the renewable versus non-renewable share in power generating capacity. And it really is, it's pretty striking how quickly and how much the solar and wind and other renewables are growing compared to the traditional power capacity investments. And that's, that's underpinning the disputes that we're seeing, and it seems to be continuing as well. I think on the right side, you can see a reason to think that this will potentially even accelerate. And the relationships on this graph on the right side show that in 2010, and that's the left portion of each section, is the average cost of production in 2010, first for solar, concentrated solar, offshore wind, and then onshore wind. And you can see there's quite a range in 2010. Those costs have fallen dramatically by 2021. And what's even more interesting is that gray line across that gray section across the bottom of the graph is the average cost for fossil fuels. So you can see that we started in 2010 with costs that were significantly higher than the fossil fuels. And of course, that created a subsidy situation that we saw, that in order to attract solar or other types of renewable investment, there needed to be some sort of subsidy scheme. Well, now we're at a point where not only are these renewable sources competitive, but they're actually beating out fossil fuels. So one source of disputes might be moving off the table, but at the same time increasing the amount of investment coming in for these types of investments is also going on. So I think you'll probably see a bit of a counterbalance and new issues coming up. So Luis already talked a little bit about this, but some of the characteristics of renewable energy that make it a fertile ground for disputes is some of the ones we've listed here, that they're heavily regulated and it's capital intensive. And because of that capital intensive element, there's an impact on local communities and national economies because it is regulated as well. It's also multi-phased, so you see development, construction, operational phases over a fairly significant period of time. So that can lead to not only construction disputes, but investment disputes, and then exposure to changing regulations as well. So you have multiple areas of exposure along the lifespan of these investments. And then you have a mix of stakeholders involved, right? So you've got regulators, you've got separate operators, you've got contractors and investors, and then also consumers as well. And then another element is the long-term agreements, and this is a basis for a lot of disputes. Long-term agreements over the life of these projects is, we're talking about 25 to 30 years. These projects have lifespans for, which is a lot of exposure, particularly when, as we showed on the previous slide, there are significant changes in costs going on, as well as the behind the scenes changes in the worldview about renewable energy and the need to transition to it. So a 25, 30-year span is significant. And then the last element here is a significant use of debt financing. Debt financing here is used to increase returns to the equity holders, but in the process, it also exposes those equity holders to more risk. So smaller changes in pricing can create bigger changes in returns. So far, when we've looked across the cases that we've seen come out over the last few years, the ones I showed on the first screen, the quantum debate is typically around a few key issues. One is the useful life of a plant. I touched on that, but there's a lot of debate about how long one expects the life of the plant to be versus realistically, is that plant going to be technologically relevant in 25 to 30 years? There's always risk of future cash flows. The discount rate is always a debate in these cases. And that's true in almost any investor state case. So that's consistent here. There's also been a tax carve-out dispute. So should taxes or claimed damages from taxes be included? And those were, in the case of Spain, a revenue tax, a 7% revenue tax. And so far that has not succeeded. Those have not been included in damages. You see a lot of discussion about due diligence and documentation. So how much diligence did the investors do into the returns that they should have expected and the risks that they have of achieving those returns? And what expectation were the investments made on? So there's been a lot of discussion of that type of documentation. But this last one, I think, is the biggest issue at the core of these awards, and it's still hotly debated. So there's not really, in my mind, one way the tribunals have leaned, and that is around legitimate expectations of returns, and falls into two categories. Is the investor, should they expect a reasonable rate of return or a fixed stable return? And so when I say reasonable rate of return, what am I talking about? In the investment world, typically a reasonable rate of return is tantamount to cost of capital, or slightly above the cost of capital of a project. And a cost of capital is defined as what is the return that's required to have investors attracted to an investment. And that can change over time, as we've seen, as interest rates change and the macroeconomy changes. The reasonable rate of return for investments can change over time. We look to markets as finance professionals. We look to the markets to determine what the market is rewarding investors with as rates of return, and that's different for across industries. And solar and wind is no exception to that. So we can look to the market to see what a reasonable rate of return is considered at a point in time. And then a fixed stable return is really going back to this idea that a single rate was agreed to for the life of a project. Those rates are typically adjusted by inflation, but it's that rate, and regardless of what's going on around the project, that rate is what that project should return. And so here I've just copied some brief summaries of two cases that show this contrast. On the left is a reasonable rate of return, REEF v. Spain. And you can see here that the tribunal basically said that claimants only had a legitimate expectation that they would receive a reasonable return on their investment, and not that the regulatory framework would remain unchanged. And you can see here in the middle, those modifications, they say, as long as they're reasonable and equitable, those would fall within a legitimate change for the regulatory framework. And this tribunal decided that what a reasonable rate of return was for REEF was the cost of capital, which is the WACC there, plus 1%. So they did recognize that maybe the 1% was a recognition that there had to be more of a return than the cost of capital to attract investors to that investment. On the right, we have a good example of a fixed rate. And here you can see that we summarize that while it's important to respect the state's right to regulate, the tribunal said this right should not trump specific promises of stability. And this goes back to that point I was making about documentation in these cases. This case certainly highlighted the fact that investors had invested with a specific rate for the life of the project in mind. And so the tribunal highlighted that. And you can see that in this middle part of that box, it said claimant would not have invested without the expectation of the fixed tariff stability. And then when we say fixed tariff, as I mentioned earlier, it is inflation adjusted, but that's assumed over the life of the project. So those are my comments on that topic, Christina.
Thank you, Garrett. That was also an extremely informative presentation based on empirical analysis and analysis of key quantum issues. We're going to now turn to energy policy and regulation. Julie, you also are a quantum expert, but you approach these issues through a different lens of regulatory policy. So what are some of the policy implications of transitioning away from fossil fuels to sources of renewable energy? And perhaps, Garrett, you can stop the screen sharing.
I'm sorry.
That's okay. Thanks, Christina, and good afternoon, good evening, and good morning to all. Let me share my screen. And hopefully everyone can see that. The place to start to answer the important question is to first acknowledge that we have just begun to address our most pressing global environmental goals to reduce carbon emissions, greenhouse gases that negatively impact our climate. And then second, in fact, we continue to use a lot of fossil fuels today that are carbon emitting. As shown in my first chart, 70% of our global energy consumption has consistently come from fossil fuels, oil, gas, and coal, shown in orange, gray, and dark blue portions of the pie charts on the slide since 1990. The 70% fossil fuel proportion excludes electricity, which also includes fossil fuels, and we'll talk about that shortly. The 70% fossil fuel proportion is consistent over time, even though substantial growth in energy consumption has occurred, with a 50% increase in 3 decades due to surging economic development around the world, and in particular, the Asia-Pacific region. Indeed, energy consumption and economic development go hand in hand. You can also see from this chart that electricity consumption has increased from 13 to 20% in the last 3 decades. That's the light blue portion of the pie chart. That brings us to my next chart in order to take a closer look at today's electricity sector. Most of our past energy regulatory policies have focused on the electricity sector. That's an important fact since only 20% of our global energy consumption is electricity. 80% is not. The historical energy policies that began decades ago were simple form, incentivizing more renewables to be built, particularly wind and solar resources, the types of renewable dispute cases that Luis and Garrett discussed. These policies were helpful as initial starting point to facilitate new technology to economically compete with traditional fossil fuels, to help them come down the cost curve, to become lower cost resources. And what you see is many country-specific electricity policies, few regional, and few really address the global nature of policy and the issue we have with carbon. You know, countries have agreed to decrease overall greenhouse gas emissions. Those are long distant periods in time where those commitments exist. Some energy policies were directed to all sources of carbon emissions, but those are few and far between. Overall, global electricity generation from fossil fuel is approximately the same proportion today as it was in 1990. That's about 60%. The bar chart on the right shows that in the electricity sector, 30% of our global electricity is from coal, that's the dark blue, 24% from natural gas, gray, and 2% from oil. Today, we have a lot less nuclear power, which is non-carbon emitting fuel, than we did in the past. We also have new wind and solar at 12%. Those are mostly what we've seen out of the new regulatory incentives. There's a small impact on our global electricity consumption because we get limited production only when the wind blows and the sun shines. So you can add a lot of capacity, but the utilization is very low, call it 30%. We have a fair amount of hydroelectric. That asset and resource has long been economic, so it didn't have the same new technology needs that a wind and a solar did. And that's presumably why we don't see as many cases on the hydro side. Now, let's switch our discussion from energy consumption to greenhouse gas emissions. Today, our global greenhouse gas emissions are comprised substantially of coal, over 44%. Then oil, 30%, and then little over, and then natural gas, approximately 22%. Geographically, our greenhouse gas emissions today in the right pie chart are substantially from the Asia Pacific region. You see that in the dark blue. You see that in the dark blue area on the right pie chart. Slide also shows that carbon emissions have grown significantly since 1990, more than 60%, 21 billion tons to 33 billion tons, generally sized by the depicted in the pie charts. The rise in emissions from economic development and energy consumption caused this, but it was worsened by substantial additional coal use. Looking at where we are today from the lens of global carbon emission levels, our past global energy policies are inadequate and suboptimal to address the carbon emissions climate goals. Challenges have existed in many forms. To name a few, first challenge I refer to as the lost decade for misspecifying the problem. That's particularly a US issue. The goal is to reduce carbon. It's not specifically to add renewables or eliminate fossils. Second challenge, energy policy has become politicized. There's lots of blame to spread around, but the bottom line is that not working together for the best solution has failed us so far. And then thirdly, a third challenge is we didn't broadly or sufficiently have a carbon tax or address the global nature of carbon, including from an international trade aspect. A carbon tax, a price on carbon, is the most economically efficient approach that leads to the lowest cost. It casts a wide net of potential solution and leads to the highest probability success. Now, as a result of these challenges, we've had many lost opportunities. We didn't find a solution for coal, which dominates our global greenhouse gas emissions, and carbon-free nuclear wasn't good enough. We didn't get all industries to be carbon focused to reduce their carbon use and demand of carbon, if you will. You know, today we're seeing engineers seek to design concrete and steel building structures with less carbon. That would have been helpful to have started that process a decade ago. And additionally, we have many unintended consequences from our challenges. Electric vehicle growth in places like China, where coal fuels electricity, actually increases greenhouse gas emissions because coal has a 35% more carbon intensity than gasoline. And oh, by the way, twice as carbon intensive as natural gas. So what are we specifically seeing in today's energy policies? In the US, we have very large investments in renewables and electric vehicles and batteries to store our intermittent wind and solar, and some hydrogen that we hope will replace natural gas. Potential substantial amounts of carbon capture and storage are on the front possibility as well. We're spending a lot of money, but we're picking and choosing winners, which is distortive economically and leads to a suboptimal solution. That is, I spend too much and I don't get as much of the result from it. On the European policy front, there's more renewables and battery and extra interest in hydrogen. There's a goal to cease making new petroleum vehicles starting in 2035. In addition, finalization of what's referred to as a carbon border adjustment mechanism, which has occurred recently, which is a fee or tax on imports of highest carbon industries, cement, iron, steel, and aluminum. That fee is tracking the impact of full global life cycle emissions on the final good consumed in Europe. Turning to the Asia Pacific region, there are relatively new carbon tax in China. There's substantial subsidy, tax breaks, and other policy incentives, which have made China an EV powerhouse. India has just introduced legislation for a carbon tax as well. So there are lots of things going on. However, the timing of progress towards significant greenhouse gas reductions is impossible to predict. Asia has headwinds with economic growth and environmental goals having to be balanced. The US and the Europe, since the majority of our future carbon emissions are coming increasingly from petroleum, from transportation, electric vehicles or alternative fuel vehicles are challenging in that they are not an immediate solution. Even the IEA estimates that only 5% reduction in global oil consumption in 2030 will occur from the stated electric vehicle goals. Now, let's just fast forward a bit and move to the implications of all of today's efforts. And let's just assume the US and Europe are successful and are able to substantially reduce our carbon emissions to nearly zero. If that were to happen with what we see today going on in investments, it'd be renewable, it'd be hydrogen, it'd be lots of carbon capture, which big oil is investing largely into these days. We'd still see the traditional vehicles, they would just be taking carbon out of the air and storing it more safely underground. If the US and Europe goes to zero, where would we be? Well, since the majority of global greenhouse gas emissions are from coal, we are at least still 25% above the level that the IPCC says is needed to limit global warming sufficiently to 1.5 degrees Celsius. Simply put, if we don't find a solution for coal, we don't achieve the global environmental goals. We become heavily dependent on a technological breakthrough of carbon abatement in coal. Now, it's not impossible. Innovation in US shale and gas created a reversal of fortunes for the US from oil and gas importers to energy independent exporters. And that occurred in less than a decade's time. But more global focus and investment is needed to solve our global issues. I look around and I see new tech ideas abound today. A few include ammonia burning with coal that would greatly reduce emissions. We see greater activity and investments in coal with carbon capture storage. We see alternatives of non-coal steel manufacturing. We see fossil fuel power plants that new tests of using carbon as a fuel. I can't predict the technology winners, and no one else can. In 2016, when I first started tracking in my Georgetown class the new technologies, I only really saw a handful of new inventions and ideas every year. Now I see many, many dozens of new ideas every year. And that's a very positive development. In some, there is urgency. However, technological innovation is ripe for an unexpected solution and should give us some optimism for the future. The future certainly will not look like it does today, but it's also not predetermined to look in any specific way. So with that, that concludes my commentary on energy policy.
Thank you, Julie. That's a very sobering presentation. I'm going to ask Lisa, perhaps, now, can you tell us some lessons? Are there any lessons to be drawn from the perspective of a policymaker from the evolution in policies in the last 10 years?
Yeah, thanks, Julie. That really was excellent. And it really was sobering. And I think it also intersected quite well with the rest of the discussion, because you rightfully emphasized how complicated things are, how dynamic things are, that betting on certain winners, trying certain policies doesn't necessarily mean that those are the right policies, that we're moving in an uncertain landscape. So I think that that's just, by the way, a really critical message. I think if I could emphasize in 2 minutes, one takeaway for me that draws a bit on Julie and also on my own, on Julie's presentation and also on my own work in this area, it's that decarbonizing the economy and scaling up alternative energy solutions doesn't happen piecemeal. It doesn't happen by betting on certain technologies sector by sector. It requires robust national, even regional planning, as I think Julie emphasized. It really requires having a roadmap for decarbonization and an energy master plan at a national scale and at a regional scale, because energy generation and distribution is often regional for some of the reasons that Julie also emphasized, that different types of generation, especially in renewable energies, are necessarily geographic dependent. They're where the sun is, the wind is, the water, and so on. But they're distributed more regionally. So what this is going to require is, I would say, twofold, and then I'll stop on that point. One is real planning at a national level and a regional level. How are we going to achieve these goals? What is our energy mix? What's available to us in terms of energy sources? Who are our energy partners? What does that imply in terms of where we need to scale up energy? What does it imply in terms of we need to phase out certain energy solutions? And then how do we achieve that what's public investments, what's private investments, and so on? That would be one point. And then my second point is a gratuitous plug for a report that we wrote, that I put the link into the chat for a different reason, which is that even with that master plan and even with a roadmap, a national or regional roadmap, there remain many constraints and challenges to actually achieving this. Julie emphasized many of them. We need to understand what they are. What are the challenges that states are facing in attracting investments, that investors are facing in attracting investments, and of relevance to our discussion based on surveys, based on what we know about the sector, based on the challenges that we can observe from history and so on. It's not the lack of treaty protections. There are real challenges in terms of affordable finance, in terms of robust utilities, in terms of access to the grid, in terms of offtake. That's in every region. There was a great article, very sobering also, about the challenges of grid interconnection in the US. Most of this access to finance capital, most of the access to low cost capital are in the developing countries and so on. So we should be doing, and governments need to be leading this, a really robust assessment of what the roadblocks are. And then our discussion about how to address that in the context of international governance, investment governance, should flow from that.
That's a perfect segue, I think, Lisa, to the final topic. So I'm going to stay with you on this particular topic of ISDS reform. Have you observed any proposed or adopted reforms that are specific to energy transition? And relatedly, do you anticipate any challenges in moving this agenda forward?
Challenges, yes. But reform options, yes. So this is, again, a really dynamic space. Let me start on what I see happening, because I think there are reform efforts happening bilaterally. So in the context of certain, well, actually, even within the context of states' model treaties and thinking through their own investment policy, there's reform efforts bilaterally in the context of specific treaties. There are efforts multilaterally, and there I will draw attention to the reform efforts of the Energy Charter Treaty. And then there are even broader multilateral discussions, for instance, most notably, I would say right now in the context of the OECD that is leading a discussion on this. And then finally, but I'll be brief, there are reform efforts that I think are proposed by civil society, and including us. We're not an advocacy organization, we're an academic institution. So just very, very briefly to go through each of those, I think the types of reforms that are largely happening by states in their models and in bilateral negotiations is largely, for the moment, limited to clarifying or limiting the scope of certain types of substantive provisions, or inserting more language into treaties with respect to general or specific exceptions that reinforce states' policy space, or that may accept certain types of measures or certain sectors and so on. That's been true for other public policy areas, but now especially environmental protection and to some degree climate measures are being integrated in that type of approach. I'll just note there a wonderful book by Wolfgang Alschner from the University of Ottawa, who has written a book on, I don't remember the exact title, but New Treaties, Old Outcomes. And he pretty systematically documents the challenges that states face in realizing their goals with these types of modifications in the outcomes of tribunal cases. And he gives many reasons for that, but at least a couple are that the existence of the 3,000 treaties, old, quote unquote, old generation treaties, have really entrenched interpretation of key provisions for arbitrators, and that arbitrators are relying on old case law and old treaties and the interpretation of new treaties, so they're minimizing some of these new types of provisions and exceptions. And of course, another reason is that there's increasing creativity and bringing claims and some treaty shopping and so on. So because these reforms are happening in certain bilateral treaties, or not even in the case of models, they're not yet at the scale that we would see a systematic effectiveness, I think, yet. The second that I thought I'd emphasize is in the context of the Energy Charter Treaty, which is probably the most concerted reform effort that we're seeing in the context of the current investment regime. Starting in 2018, the Energy Charter Treaty set out to quote unquote modernize the Energy Charter Treaty. That was 3 years after the adoption of the Paris Agreement. Although even then, when they identified the list of topics that would be part of the modernization effort, there was very little, if I'm being generous, effort to really align with the Paris goals. And I think that set them on a failing track, in my view, to meaningfully think about how an energy charter treaty, which could and should have been a core instrument in achieving the climate goals through an investment treaty, could and should indeed align with the climate goals. And so it doesn't. So what the Energy Charter Treaty reform efforts have looked like is frankly largely what I just described in the bilateral context. So a number of proposed changes to provisions into ISDS that are, again, quite similar to those in other treaties that have had limited or dubious effect. There's a proposed new article on climate change and clean energy transition, which as drafted is largely reaffirming the members' existing commitments to cooperation on a number of climate, energy, and trade matters. They've introduced a flexibility mechanism that allows members to unilaterally exclude investor protections for fossil fuels, although even the leading states that are supporting the modernization have indicated that they're unlikely to use that flexibility mechanism, and others are likely to be even more conservative. So it's not looking likely that that would be widely adopted. And then, despite concerns regarding ISDS in all sectors, not just with respect to fossil fuels, but how it can bind states' hands as they're trying to dynamically evolve their policies, it actually extends ISDS and the scope of ISDS to a number of other critical policy areas, including with respect to hydrogen and biomass and biogas and synthetic fuels and so on, which is probably moving in the opposite direction than climate campaigners would have liked to have seen. So, the modernization effort has faced substantial headwinds from those in the climate community, I would say. And again, as I alluded to earlier, a number of EU states have already indicated that despite these modernization attempts, they are planning to withdraw from the ECT. And the remaining question is whether the EU will do so as a whole or whether individual states will. And I think how that pans out, we're in that moment right now. The other reform effort that I mentioned was at the OECD. They've been convening a discussion on the alignment of investment treaties with the Paris Agreement and net zero. I think this was the second year that they've convened a conference. It just happened last month. The first one was last year, where they're soliciting inputs from a number of interested stakeholders in what it would look like to align treaties. Oh my gosh, lots banging out here. I just noted in preparation for speaking today one paragraph that I thought notable from some of their background materials for this year's conference. One of the background materials that they prepared for this year's conference was actually a stock taking of critical agreements that states have made with respect to climate policy in all those fora that I previously mentioned, at G7 meetings, G20 meetings, ministerial conventions, and so on. So they have a background document that lists many of those meetings and commitments. And then the OECD says, while government commitments to tackle climate change have become frequent, it can be difficult to see changes in investment treaties or their associated finance flows. In addition, while there are multiple intergovernmental groups addressing sustainable finance or the climate effects of trade, it's unclear whether governments have included investment treaties in their finance flows in this work. Overall, despite the many initiatives and commitments, it's unclear if governments are addressing the alignment of investment treaty incentives with the Paris Agreement and sustainable finance in any other ongoing work. So I think that nicely summarizes where we are with respect to investment treaties and meaningful reform around climate. The main call for reform among civil society is predominantly, I think, to fundamentally reform ISDS, because climate is added to the list of critical policy areas that are being successfully challenged and creating a chill for government policy, even when we are not seeing the claims, or even for favorable awards, there's increasing evidence that states are being chilled and taking critical policy measures. So I think from civil society, the major call is for reform of the ISDS system as a whole. And then I'll just end with reiterating our conclusions and finding from that I was just alluding to after Julie's presentation, but I really think that it's the core of where reform discussions should be, which is that investment plays the central role in the energy transition. We need to mobilize trillions of dollars of investment. We need to properly govern that investment. It's incredibly complicated. And that's why I love investment governance and investment law, because it is so decisive in whether we are able to achieve our goals. But that really requires a fundamental rethink of what it is, what are the problems that we're trying to solve? What are the roadblocks that are impeding the financial flows that are needed, and what are solutions that we can bring? What needs to happen at a national level? What needs to happen at an international level? So I would suggest that we start the reform discussions there, because there's an absolutely critical role for investment governance, but it's certainly not clear that the problem is with the lack of investment protections in investment treaties. The evidence that investment treaties have been effective at mobilizing investment is weak at best. And as Julie indicated, we're not solving the problem. So for me, this is a real call to action for our community to really rethink what are the barriers, what are the challenges, how do we address those fundamentally? How do we anticipate the types of disputes that my fellow panelists have helpfully previewed before they arise? And how do we resolve them in a way that's consistent with our global efforts to address climate change? I'll stop there.
Thank you for that summary of various initiatives, and potentially also carving out the agenda looking forward. I'm going to give Louise the last word before we open up the Q&A. Louise, do you have anything you'd like to add on this topic?
Just to say that I've loved hearing from all the other panelists so far, and I think, you know, Lisa, those last points are particularly thorny and very interesting. I think, you know, thinking about this wider question of the legitimacy of the ISDS system, this is of course very closely connected with the current development of these energy transition and climate change related cases, because they really do represent a very pointed challenge to the idea that states should be entirely unfettered in the measures that they take in pursuit of climate change. And so to the extent there's already some skepticism and hostility towards this system, it's really being made much more pronounced in this context. I don't have an easy answer to that. I think there's 2 points to note. One is that in its 2022 report, the IPCC identified ISDS as one of the key barriers to addressing climate change, and saying that it's stopping countries from legislating for climate change. And then that kind of represents one side of this debate here. But it's interesting in that context to then see all of the efforts that are being put into, rather than abandoning the system as such, I guess more reshaping it through this new generation of treaties, and especially this interest in setting out more reciprocal obligations around environment and climate change. The final 2 points I'll make are just that I think as has always been the case with investment treaty arbitration, and the way it's described outside of the specialist legal sector that kind of engages in it in a lot of detail, sometimes the descriptions of the cases is, I think, a little simplistic, and I think it can obscure some important details. For example, a lot of the descriptions of the Uniper and RWE cases against the Netherlands just reported them as, there were companies suing the Netherlands in connection with the phase out of coal-fired power generation. Whereas actually, when you look at them more closely, it's about the what they said was the more arbitrary application of the compensation mechanism, which is arguably a different proposition. And I think it's interesting to look at the angles that are being presented when these issues are being discussed. And I think that there is some nuance to the challenges that are being obscured at times. And my final point is, it's a point that's been picked up in the questions in the chat already, which is about how can ISDS be actually used to encourage climate change action and to facilitate it. And I think looking at the growth that is expected in Africa, for example, as turning into a kind of green energy continent, that will involve a huge amount of investment over the coming decades. And that is what ISDS was traditionally supposed to enable and encourage, especially where you're dealing with sectors that are founded on newer technology or rapidly developing regulation, for example, around green hydrogen. Then I think it's interesting to think about the role of these sort of treaties in creating confidence among the kind of foreign investment sector. Again, I don't think there is actually a straightforward answer to this, but I think that's another factor that should be considered.
Thank you, Louise. So what I propose to do is just summarize the questions that have come in the chat, and perhaps give you all an opportunity to comment on some or all of these questions. So the first has to do with this last issue that Louise touched on, and whether investment treaties are really antithetical to climate change reform, or whether they can be used in a way to advance or protect investments in alternative non-fossil fuel energies. That's question one. Question two is how to essentially increase the chances for a state's success in making a counterclaim related to climate change and environmental measure. Question three relates to whether there would be any rise in new energy charter treaty claims that might be expected in the next 4 years. And that question was particularly directed to Lisa. And then the final question by Eureka: do you see any future participation of civil society or international organizations as amicus curiae? So I will perhaps start with Julie, and then Garrett, Louise, and Lisa.
I mean, I think those were more charter related questions. I didn't hear, I'll defer to others.
Garrett, do you have anything to add, or shall we?
Yeah, I mean, similar to Julia, I think a lot of those are more legal based. Having seen, having worked on these cases, and there was one question in there about the effectiveness of treaties in facilitating investment or creating investment. We get to look at the inside of the engine, right? Because we get to see sort of what investors were thinking. And I do think that a lot of the investments that have been made that are subject to disputes were made partially because they felt like there was protection from treaties. So I would say that, treaties do provide, at least in my experience, incentive for investment.
Louise?
Yeah, I mean, on that last point, this is something that I am engaged in on a day-to-day basis is talking to companies who are thinking of making investments, and this is something that is certainly a factor in the discussions that we're having. It might be, as the treaty system evolves over time, it might be that there is more interest in other forms of investment protection, like stabilization clauses in specific investment contracts with states and with state entities. So it might be that some of this is kind of ending up being located in different types of legal instruments over time. I think on the point about counterclaims and the overcoming the challenge of consent to an investor being subject to a counterclaim, but this is a major issue, and I think this is why we've seen so few instances of success of counterclaims. The main exception being the Burlington v. Ecuador case. In that instance, the parties agreed to submit to the jurisdiction of the tribunal for those counterclaims for a range of reasons that were specific to that case. And the obligations that were said to apply to the investor arose from domestic tort law. So there's a lot of factors that are specific to the circumstances of that case, which allowed the counterclaim to be effective. I think what we've been discussing here, what Lisa's been talking about in particular, is the changes to treaties that might allow claims arising from obligations that are said to subsist in the treaty itself, rather than necessarily from domestic law, which is a really interesting and slightly different question. The investment treaty system has, of course, conventionally operated as a fairly one-way street, as a kind of option which can be taken up by the investor, and this would fundamentally change that. So it's interesting to see the way that sort of issue is being grappled with in this newer generation of treaties. But we're still seeing the vast majority of cases that have been brought of late, that are still being brought now, are under this much older generation of treaties. And so I think it will be quite some time until we see those newer mechanisms, to the extent that they're actually agreed in these treaties, becoming effective.
And over to you, Lisa, for the last word.
Great, thanks. I think, as I emphasize, this question of what the real roadblocks are is really critical for us to unpack, and it's clearly contested with anecdotal evidence, with survey evidence, with empirical evidence, and so on. So it's certainly not straightforward. I edited a book on this topic in 2008, too long ago to admit. Even then, the evidence was, not strong that treaties are effective at mobilizing investment. And then most recently, that I'm aware of a meta study in 2021 that was an empirical meta study of 74 empirical studies, and it found the effect of these treaties to be so negligible as to be zero. So at least let me just say that it deserves real questioning, because it has substantial impacts on states and on policies. And so at least let us know, and let us really critically evaluate the benefits. And by the way, for all of the lawyers, it's not to say that disputes, there'll always be disputes. There'll always be mechanisms to mitigate disputes, to bring actually, I just wanted to mention with respect to what Louise said, that because we did the survey of investors in renewable energy to understand what they care about. And the idea of certain types of legal certainty absolutely comes through, but that's a concept that should be unpacked, because legal certainty can be realized through many different types of instruments. And actually, when you ask what matters, is clarity over offtake agreements and certainty over, and standardized PPAs that explain rate adjustments and so on. So we should better understand what it is, where we can embed legal certainty in ways that also don't undermine states' policy space. So it's a tricky question. I'm also interested in the example from Brazil, where Brazil asked their investors, and they're not called bilateral investment treaties, they call them investment cooperation and facilitation agreements. It's Brazil's model. And they asked their investors, what matters to you? They did a survey of their investors before concluding and negotiating these treaties, and they don't have ISDS in their treaties. It looks quite different. So again, there's enough evidence that we should be asking the question and not presuming that ISDS is necessary or the right model, and how do we adapt around it, but that we really try to understand what is, again, for those of us who are trying to achieve the energy transition, what are the real barriers? What are the challenges that investors are facing, and how do we achieve that? And how do we achieve that in a way that benefits all stakeholders? Because, by the way, to the extent that there's a concern that that domestic judicial systems are not sufficient, that affects all stakeholders. So if it's that we need more robust judicial systems, that's also something I think we should be considering. So anyway, I think I like this open, critical discussion about how the premises, I would say, on which these treaties are based. And maybe I'll just use that to answer, as I did in the chat, the last question about the ECT and whether it could take a different form. And I like to think, yes, I believe very much that we need international investment governance, and that we need international cooperation, and that we need international mechanisms. But I would say that it should look quite different, that it should be based on the starting point of what are we trying to achieve? What kind of investment do we need globally? Where do we want to drive that investment? Where do we not want to drive the investment? What types of investments do we not want to encourage? What are the challenges that states are facing? What are in both attracting, but also in governing their investment? And how do we design mechanisms that are supportive of those policies and that are supportive of those goals? So I would love to see model treaties that look like that, but it would be quite different from the existing forms that we have.
Thank you, Lisa. This brings us to the end of the formal portion of our session. I want to thank all the panelists for their truly thoughtful presentations, and I turn the floor now over to our hosts, Jose Antonio and Ian.
Got to get the mute off. So that was really fantastic. This is a discussion that certainly an hour and a half didn't do sufficient merit to. I just wanted to thank our panelists. You've clearly spent a lot of time in preparation thinking about these issues, and thank you very much. And thank you, Christina, for your usual masterful moderation of this panel. I know a lot of work went into organizing this, and really appreciate those efforts. And just a final note to all of our attendees online and around the world. We have more World Arbitration Update coming up this evening. We're moving to Oceania this evening, which is tomorrow morning in Hong Kong and Singapore. And again, I wanted to remind folks that tonight at 8 p.m. Eastern time, but 8 a.m. in Singapore and Hong Kong, we have the role of domestic legislations on evidence in international arbitration proceedings, clash of legal cultures, and taking of evidence in international arbitration, which I think will be a great topic, and I'm looking forward to it. Jose Antonio, anything you want to close with?
Just to say that it was a fantastic panel, and that from the moderator to the presenter to each one of the panelists, it's highly appreciated that there are so many views and substance, and that it is a vital topic, for survival of life in itself, but also how to use or not models of arbitration, investment treaties, or alternatives Thank you, everyone. And now I believe that we should move into the breakout rooms. There are people who would love to see the speakers, and as you know, we have the breakout rooms as a way to communicate with people that are not in the same jurisdiction in an intergenerational manner. No need to talk about the substance of the panel, but of course that is an option. So thank you, and then we'll see you in a few hours in Asia Day as the sun is about to come there. Bye bye.